Good afternoon, everybody. My name is Russell Wilcox, and my colleague here is Katie Ayres. This is a rerun of a webinar that we gave just over 2 weeks ago. And unfortunately, on that occasion, we were very much hampered by technical glitches, which meant that the presentation was far from as smooth as we would have hoped. And it actually led to the complete exclusion of Katie. So we've decided to give the presentation again. Those of you who have come back for the second time, we are very grateful. And those of you who are logging on for the first time, you're most welcome. The presentation that we seek to or that we're going to give today is entitled Damages Claims Against the Home Office, the Implications of Hans Husson. As it says on the tin, it's effectively a review of the facts and the reasoning in the Court of Appeal case Hans Husson and the Secretary of State, or the Crown Hans Husson, on the application of Hans Husson against the Secretary of State for the Home Department, which was decided, I think, in March. The decision was handed down. And we hope that in analysing reasoning, we can say something useful about the implications of this case for bringing damages claims against the Home Office, as well as government bodies more generally. There were effectively two substantive grounds considered by the Court of Appeal. The first was a damages claim under Article 8 of the European Convention on Human Rights, and the second was whether or not there was a claim, a common law claim in negligence on the basis of assumption of responsibility against the Home Office. I will set out the brief factual background and procedural history and deal in the first instance with the Article 8 claim, and then I will hand over to Katie to deal with the common law claim, which she is in negligence, which she is especially well qualified to comment on, given that she was one of the junior counsel in the Supreme Court case of Paul Borough Council, which is currently the leading authority on the question of assumption of responsibility. So I'll jump straight into the facts then. If we go to the second, just get the slides going. Yes. So Hans Husson came to the United Kingdom, as it says on the slide, from Mauritius as a visitor in July 2004. He obtained leave to remain as a student nurse, which was extended till November 2007, after which he applied for and was refused leave to remain under Articles 3 and 8 of the ECHR. In February 2010, he married a British citizen and they subsequently had a child together. And thereafter, he sought to reopen the refusal of leave to remain by way of a request for reconsideration and the making of further representations. And finally, when that was unsuccessful, by issuing judicial review proceedings. Initially, permission to bring judicial review was refused, and in due course the matter made its way up to the Court of Appeal in late 2015. Parties at that stage agreed to settle proceedings by way of a consent order. The terms of that agreement were set out in a recital to the consent order, and the order itself was sealed by Lord Justice Tomlinson on the 26th of November 2016. The agreement was that Hans Husson's application, together with any further representations he wished to rely upon, would be determined within 3 months of the receipt of those further representations. In compliance with the order, a letter dated the 20th of May 2016, and as I've mentioned, within the agreed 3-month period, was sent by the respondent to Hans Husson, and in it he was granted, he was informed that he'd been granted 30 months leave to remain, valid until the 20th of November 2018. It added, and this is important, that a biometrics residence permit would be sent separately within 7 working days, but that if it had not arrived within 10 days, Hans Husson should follow up with the respondent. And I'm sure everybody attending knows, but those who are unfamiliar with immigration law should be informed that biometrics residence permit is effectively the official card with the biometric data on it, as it says, which an individual who has leave to remain is given, on which he can show to people to establish that he has the right to do a number of things, including to work. And it is effectively a sine qua non for an individual with the status of Mr. Husson to be able to secure employment. As it transpired, Mr. Husson was not sent the biometrics residence permit within 7 to 10 days. On the 22nd of May, he was sent his passport back, but despite numerous chases, his biometrics residence permit was not issued until some 2 years later, on the 19th of June 2018. In due course, Mr. Husson sought to challenge the delay in issuing the biometrics residence permit by a second round of judicial review, initiating a second round of judicial review proceedings, in part on the basis that the delay had been unlawful and that it gave rise to a claim in damages. At first instance, in the upper tribunal, it was refused, permission to bring judicial review, an application for judicial review was refused on the papers, and upon oral renewal, it was again refused, this time by Upper Tribunal Judge King, on the basis first that the tribunal simply did not have jurisdiction to consider a claim for a breach of duty of care or statutory duty, that is the Upper Tribunal. And secondly, that whilst there may be a cause of damage for damages for breach of human rights, to mount such a claim, it was necessary to establish a deprivation of the right to work, or of the ability to work altogether. And on the facts of Mr. Husson's case, he couldn't do that, in light of the respondent's assurance at the time that when he was returned his passport, his right to work would have been clearly endorsed in it following his grant of leave to remain. Now, from that point, a further appeal was made to the Court of Appeal and permission was granted. It's important to recognise that the matter that was dealt with, or the question that was dealt with by the Court of Appeal, was whether or not permission to bring judicial review proceedings should be granted. And so all of the arguments were tested against the yardstick of arguability. Nevertheless, and it'd be interesting to see what Katie thinks about this, but nevertheless, it's my view that some of, or the reasoning of the Court of Appeal, it has wider application. Importantly, by the time it reached the Court of Appeal, it had been accepted by the Secretary of State that Hans Husson's passport would not in fact have been endorsed with the right to work or with the grant of leave to remain, and that consequently his passport would not, contrary to what had been represented before Upper Tribunal Judge King, would not have been acceptable to an employer demonstrating his right to work. This was a significant factual concession because what really seemed to persuade Upper Tribunal Judge King was the reasoning in the case of the Crown on the application of Atapatu versus the Secretary of State for the Home Department, which was a High Court case decided in 2011 by Morris QC, as he then was sitting as a Deputy High Court Judge. That referred to the underlying ECHR case law, and in particularly the cases of Sidobras and Ukraine and Smirnov and Russia, as authority that a claim for damages for a breach of human rights could only really be brought in the extreme circumstances where the claimant's ability to work had been wholly or very substantially deprived. And because at the time that the matter was before Upper Tribunal Judge King, it was suggested that that was not the case. He found that there was no arguable basis for the claim. The fact, however, that Mr. Husson did not have a passport endorsed with a leave to remain and did not have a biometric residence permit meant that this issue was, or the facts of this case, arguably aligned much more closely with the European Court of Human Rights authorities. Despite this concession, perhaps somewhat surprisingly, certainly government counsel got a bit of flack for it in the arguing of the case. The respondent continued to argue that a failure to issue a biometric residence permit had not in fact deprived Hans Husson of the right to work in the relevant sense, because he could still leave the United Kingdom and go back to his own country of Mauritius to obtain employment. In relation to this point, as I've probably already indicated, the court was unimpressed. Lady Justice Simler, giving judgment, rejected these arguments, and she, go on to the next, yes. She said, whilst it was recognised that there's no direct authority establishing the right to work as being in and of itself protected by Article 8 of the ECHR, it was accepted that the authorities cited in Atapatu demonstrate that where an individual is wholly or substantially deprived of the ability to work altogether, Article 8.1 is at least arguably engaged. And she goes on to cite the old case of Anna Frajeva, Southwark London Borough Council, where Lord Wolfe recognised that where the established breach has clearly caused significant pecuniary loss, this will usually be assessed and awarded in order to comply with the requirements under the ECHR and Human Rights Act that there is an award of just satisfaction. It should be mentioned that, of course, subsequent to that rather old case, this has only been reinforced by both domestic and ECHR jurisprudence. And whilst there is still considerable controversy over how one calculates non-pecuniary loss, as long as there's a clear evidence of pecuniary loss, an award in compensation for that loss will normally follow. There are, of course, other questions as to what standard of proof applies in order to get home on that point, but the basic principle is well established. In relation to the circumstances in which Mr. Husson found himself, as you can see, paragraphs 38 and 39, Lady Justice Simler effectively says that given that it's now conceded that without a BRP, the appellant would be unable to take up any lawful employment. The only basis upon which it's now argued there wasn't total deprivation is by reference to the possibility of the appellant returning to Mauritius. This was not accepted as being a realistic alternative, and perhaps especially in view of the fact that it would involve sacrifice of other very significant Article 8 rights in terms of his relationship with his partner and child. It then goes on, or she then goes on to say, to make a number of quite striking comments as to what evidence would be required, at least to make this ground arguable. And of course, and I think it was a fair point, a lot was made that of the fact that, in fact, the evidence of loss of employment and the chance of earnings was limited. And there wasn't even at this stage a witness statement or a schedule of loss of earnings. But notwithstanding that, she says, be that as it may, in circumstances where the respondent's own policy documents make good this aspect of the appellant's case, in the sense that no employer could lawfully have employed him in the UK, it is an inevitable inference that he was deprived of all employment opportunities that were available. And it seems to me that that sentence in and of itself is very significant and makes this judgment, means this judgment has implications beyond the question of mere arguability, because Lady Justice Simler there, by using the word inevitable inference, is going beyond, it seems to me, what would be required to determine the arguability of this claim, at least in terms of there being, the first limb of it being made out. I'll now pass over to Katie to deal with the claim in negligence, which was the second substantive ground of challenge. Well, I don't need to introduce her. Sure. I'll pass over to her now. Katie.
Thanks, Russell. And just briefly, by way of introduction, for those of you who I haven't worked with, a large part of my practice involves claims where there is a crossover between negligence and Human Rights Act claims. And it's something that I specialise in because I find it very interesting. And as Russell said at the outset, I was lucky enough to be involved in CN and Poole. Interestingly, in CN and Poole, a Human Rights Act claim wasn't pursued by the claimants in that case, and it was purely a common law argument. Now, had they pursued a Human Rights Act claim, they may well have had one. So it's not entirely clear why a Human Rights Act claim wasn't pursued in that case, and it was decided purely on the basis of common law. A question that I often have to grapple with and get asked is, essentially, what's the difference in outcome between bringing a Human Rights Act claim and bringing a common law claim? Because this being Russell's case, you might say, well, he's won on the Article 8 point. Do we really care what the common law claim says? And there are different ways of looking at that. Historically, at least, under the common law, received wisdom seemed to be that you were going to get a better level of damages than you would under a Human Rights Act claim. And really, only up until a couple of years ago, I was advising on cases where the primary cause of action is in the common law, and then they essentially tack on an Article 3, Article 8 claim for an extra couple of grand, so to speak. In my opinion, the legal landscape has changed a lot in the last couple of years. And it seems most likely now that under the Human Rights Act claims, you'll be entitled to probably, although it is up for debate, the same or similar amount of damages than were you to succeed in a common law claim.
It's interesting because if I could just interject there, I actually made this point briefly to the Lord Justices, and Lord Justice McComb and Lady Justice Simler, I think, did not think it had legs, in the sense that I said, well, one of the reasons why we're pursuing both heads is that you know, there may be a higher quantum of damages if we could get home on the negligence claim. And they said, well, obviously you're entitled to pursue it, but we're not quite sure that that's, you know, that's the case. I think where there may potentially be a difference, but even this, I think, is the grounds that the sands are shifting is in terms of the level of proof which is required. Because I think in some ways, again, the conventional wisdom was that the level of proof that will be required before the ECHR would be in practice much higher than will be required in negligence claims. But I think that there is recent jurisprudence suggesting, well, the standard of proof should effectively be treated the same. But I think that might still be one area where there is some advantage in bringing a negligence claim also.
It's interesting because there is even debate around that, because there are ECHR cases that might be read to suggest that the standard of proof under the ECHR is lower than domestic jurisprudence, because you only have to be a substantial cause rather than a but-for cause under the common law. But actually, I think I completely agree with Russell in that probably the standard of proof, certainly insofar as the evidence that you're required to prove it, is probably, and for today's purposes, let's assume, the same.
Yes, yes.
I get the feeling that that's the way this is going. Interestingly, just on the damages point, there is a French case in the European Court from last year where the claimant was awarded some €8 million in damages. That's the largest award that the court had made to date. And that goes back to actually the issue of what do you have to submit to prove the damages, because historically, the way that schedules were pleaded in the European Court was very broad brush. It's not, you know, the UK law way of pleading a schedule of loss. It's, well, we think you might have lost £20,000 worth of earnings in a very broad brush way. But again, the sands are shifting on that, and cases now are realising that if you go to the European Court with a well-pleaded, detailed schedule setting out your pecuniary losses, there's no reason in principle why you shouldn't be awarded that. So I think, in answer to the question of what does the negligence cause of action in Husson's case add to the overall claim, without wishing to belittle my role here, probably not very much. And that also, we'll go on to see what the court says, but just at the outset, I reiterate what Russell said at the beginning, and that bear in mind that this is a strikeout case. And all the Court of Appeal did here was decide whether or not it was arguable. And that, as we all know, is a relatively low threshold. Were this case to have proceeded to a final determination, I am very sceptical. I hope Russell doesn't mind me saying that it would have succeeded. And indeed, the court sort of makes comments reflecting perhaps they were also sceptical. But anyway, how was the claim framed in the common law? This was a case where it was alleged that the Home Office had failed to do something. So they had failed to issue Hans Husson with his biometric residence permit within a period of time. So on the face of it, that is what has come back into fashion quite recently, being called as an omissions case. It's an omissions case rather than an acts case. The distinction being, if you step back and look at the allegations, are they that someone failed to do something and didn't act, or are they that someone acted and thereby caused harm? Obviously, in an act case, that is a paradigm example of where a duty of care arises in negligence. And for an example of that, you can look at Robinson, the Supreme Court case in 2018, I think, where the police set up a cordon to capture someone, and in doing so, unfortunately, knocked down a little old lady who was on the road at the time. And the court said, well, I don't know why you're even saying there's no duty of care here. Of course there's a duty of care, because you knocked her over. You did it. You caused that harm. So that is an act case. But what we were dealing with here, I think, and everyone can probably agree on this, is an omissions case. For an interesting discussion of the difference between acts and omissions cases, I'd urge you to have a look at the judgment of Lord Justice Coulson. It's a case this year, Calma and African Minerals. It's an incredibly long judgment, but there is a good bit in it where he talks about how you determine what is an act case and what's an omissions case. That was an interesting case factually, where the claimants sued a mining company for essentially failing to protect them from the police forces that the mining company had engaged to maintain order in the area of their operations. And actually these police forces had arguably turned a bit rogue and started harming people. Lord Justice Coulson said, stepping back from this is clearly an omissions case, it's a failure to do something. And that had been recognised by the claimants, and they tried to shoehorn their case into the exception of creating a danger creation. Now that's a topic not for today, but that is another exception to the rule that there is no liability for omissions. In brief summary, they lost. It wasn't a creation of danger situation. There was no arguable common law duty in that case. In this case, the exception that Russell sought to rely on was an assumption of responsibility, and this is a very hot topic at the moment. It is going to be a very hot topic for at least a couple of years, as various cases in various different factual areas make their way through the courts. And the reason it has become a bit of a hot topic is because of what the court said in CN and Poole. And you see on the slide, CN and Poole played a central role in Lady Justice Simler's decision in Husson. And what the court had said in CN and Poole was, 1, this is an omissions case. 2, in answering the question, does it fall into an exception whereby the defendant has assumed responsibility to the defendant? In CN, the answer was no. But as we'll see, Lady Justice Simler said, arguably in Husson, the answer is yes. CN and Poole is very good and is a comprehensive analysis of the issue. You probably at the moment don't need to read any other cases until more cases make their way through the courts. But what CN is very clear about is that a defendant does not assume a responsibility merely by operating a statutory scheme. And several different cases are analysed. For example, one I'd urge to look at is a case called Rowley, R-O-W-L-E-Y, in which it was argued that the Child Support Agency didn't act quickly enough to provide answers to a complaint of a mother in relation to the child support that she received for her 3 children. And what the court appeal said in that case was, claimants, you have not pleaded any facts over and above the administration of this statutory scheme, and just by administering a statutory scheme, you cannot thereby assume responsibility. And that goes back to the case of Stoneman and Wise. So what Russell had to do in this case was to find something else that was not just the Home Office administering the statutory scheme. On the slide, there's just reference to the cases of W. Mohammed and Atapatu again, and those are cases where it was argued that there was a common law duty of care and negligence, and all of those cases failed. They weren't decided on exactly the same factual matrix as Husson was decided on, but I think it gives you a flavour that it was very much an uphill battle in Husson. The law didn't look like, certainly, that it was on Mr. Husson's side at the outset. And there you can see in the second bullet point on the slide what I alluded to at the beginning, by bearing in mind that this is an arguability test, and in fact Lady Justice Simler uses the words that she has grave doubts as to the prospects of the appellant establishing that duty of care was owed by the respondent in the circumstances of this case. I always find those comments very odd, because on the one hand the court is saying, okay, it's arguable, but hang on, you're probably going to lose. So I find those difficult. Another case that I find very difficult is a case called Transport Arundong, which was a case that was also decided this year, a High Court case on appeal. It was a Lady in Chambers, Laura Johnson, was for the police in that case. And I'd urge you to read that case as what I call it, the sort of cop-out of the century on a strikeout. Because it is always a worry on strikeout applications where the court just says, well, okay, fine, let's just let it in and it's arguable, isn't it? Let's let it rumble on and they're probably going to lose at trial. Again, I sort of think that the decision on the common law claim in Husson was a little bit of a cop-out. But how did the court reach its decision? And again, I'm somewhat critical of the logic that the court went through in order to reach the decision. Because as I previously set out, the way in which these cases should be approached is a sort of flow chart of first question, is this an act or is this an omission? And if it's an omission, you get into the one box and you go down and you go, okay, does it fall into any of the exceptions to being no duty of care, which is the general rule for omissions? And in this case, you then turn to the concept of assumption of responsibility, which has its own distinct line of precedent stemming back from Spring and Guardian Assurance and Hedleyburn and Heller, setting out what was, or what started as being quite a niche concept of negligence to fill a gap that contract law wasn't filling. And now it's expanding into this sort of ever-growing area where loads of things seem to be caught by it. And by doing that structure, is it an omission, is it an assumption of responsibility, what you do is you should completely bypass the Caparo test. Because Lord Reed, in the series of Supreme Court judgments leading up to CN, that being Michael, Robinson, Arms, and then CN, makes it very clear, I sort of say that's his sort of project on what is duty of care, makes it very clear that if your scenario falls into an established category of negligence, that is something the courts have seen before, something upon which there is precedent, then you do not turn to Caparo and Dickman to answer the question of whether there's a duty of care. And that is very different even from when I was in law school and learning how to determine whether there is a duty of care. I mean, I remember what I was taught was you apply Caparo and Dickman. But that's not what you do now. You only apply that to novel situations. And in my opinion, what you have here is not a novel situation. You have a case that is an omissions case. So you should not go anywhere near Caparo and Dickman. However, the Court of Appeal did. And actually, probably the same conclusion would have been reached, regardless of which route they went down. So Lady Justice Simler applied the Caparo test and probably rightly concludes that there was foreseeability of harm and proximity. However, just on that note, I would say that the mere fact that Mr. Husson was in an identifiable group of people, you know, beyond the public at large, has not really found favour in some higher court decisions as establishing proximity. For example, see Michael. You're not going to get proximity just by being someone who has been in contact with the police, or just by being someone who has been in contact with child services. So question mark of whether there actually is proximity. But in any event, she reaches the conclusion that the first two limbs of Caparo are satisfied. She then moves on to the third limb of Caparo, which is fairness, justness and reasonableness. But actually what she does is, within that, she answers the question of whether there was an assumption of responsibility. So in my opinion, she's very much conflating two tests here that aren't the same test. There's distinct lines of precedent that you should apply for each of them.
Do you think if she had applied the correct question mark, because one of the noticeable things is she considers policy elements, and that's classically considered in the third stage of Caparo. Does it follow that you don't consider policy considerations if there's an established line of?
Yeah.
And if that is the case, if she had argued it in the, as you say, the correct way, would it have been more arguable?
Yeah, it's a really interesting question. So my opinion is that you don't get anywhere near policy considerations if you are already in the flow diagram going down the left-hand side of the page, answering the questions omission, assumption, responsibility. Because Headley Burn and Spring Assurance, you're nowhere near policy considerations. You are, is this everything that's a contract but for consideration? Yes. The question of whether or not the absence of policy considerations would make this a more than merely arguable case is a difficult one to answer. In my opinion, the fact that she considered policy considerations probably favoured the defendant marginally, but my personal view on whether or not the consent order could have arguably given rise to an assumption of responsibility on Spring and Guardian Headley Burn principles is that I don't think it could. Yes,
because we had an attendee of the previous incarnation of this talk, who was an associate professor of law. I forget his name, associate professor of law at Magdalen College, Oxford. He raised the interesting question. He said to me, well, why did you argue that the assumption of responsibility was on the basis of the consent order? Why didn't you argue it? And I must admit, I hadn't thought about it, on the basis of the letter of grant. And that would have certainly bypassed, had the policy considerations been relevant, would have bypassed them. So namely, the letter of grant saying that the biometrics residence permit would be there within 7 to 10 days. And the three of us had quite an interesting exchange. I think Katie made the most interesting or the most informed contributions. And I think I probably side with her. And I think she found, I think you think that that would be an even weaker basis than the consent order.
I completely agree. It goes back to what I think was done very well in Husson, was finding something that was outside the statutory scheme. I think the letter would come up against two quite significant challenges. One being, I can see a court saying, well, hang on, aren't you just administering the statutory scheme by sending in the letter that says you'll receive this within 7 to 10 days? And two, although this is a policy consideration, I don't think one should underestimate the fact that judges will be cognizant of the wider implications of these findings. So if, for example, the court found that sending a letter saying I promise to do something was sufficient to give rise to an assumption of responsibility, imagine the consequences that that would suddenly have on all forms of written correspondence. I think what the court has had in mind in Husson, which gave rise to the comment about the grave concerns issue, was, gosh, hang on. If we say that a consent order with a recital in it is sufficient to give rise to an assumption of responsibility, that also has pretty wide ramifications.
Yes.
So although they're not
On the next slide, I think the quotes from Lady Justice similar.
Thank you.
Dealing with this.
There you go, exactly. I'm doubtful that the common law duty of care can be derived from such an agreement given to support a consent order of the court. Because obviously, ordinarily in order of the court, you have the order and then your remedy lies in enforcing the order through the courts. Recitals are a slightly odd halfway house, because often I try and get them in there just because it, gives a bit of a nudge to whatever the side is to do something. But imagine if they were given legal force to be in assumption of responsibility to do something.
Well, I was mindful, and in my skeleton, I referred to the case of, I think it's MK in the upper tribunal, where Mr. Justice McCloskey dealt with this. In fact, I think First Treasury Counsel went along to argue that, and his opponent was Callahan, I think, who's now sits as an upper tribunal judge. And the question there was whether or not there could be any proceedings for contempt if there was a breach of effectively of an undertaking which was not part of the body of the order, and it was found it wasn't. But it did say that this was made in good, that it's a presupposition that anything which is contained within the recitals is made in good faith. And that's why I bore that in mind when I was sort of, and I imagine that would have been the subject of more argument had the substantive claim not settled.
Yeah.
But it also raises very interesting questions about how or whether there is likely to be either explicitly or implicitly policy considerations when it comes to consider Article 8 claims. Because of it would appear that if you've breached Article 8 and you've suffered loss, you are entitled to satisfaction. How you measure that, I think, is going to be an interesting area of
subject
discussion.
For another webinar.
Indeed. Which I suppose brings us on to the implications, which is the last slide. So I focus very much on the implications of the Article 8 point, because I think that's probably going to be most consequential, even though jurisprudentially, arguably, at least this in Husson, the assumption of responsibility, common law claiming negligence was perhaps the most interesting. But as you'll see, my view is, perhaps it's slightly over-optimistic, but that Husson has roundly approved the test contemplated in Atipatu. And the case is cited there that if somebody's been very substantially deprived of the ability to work and they suffer consequential loss, they'll be entitled to pecuniary compensation, which seems to me quite important, and something which could give rise to quite a lot of claims. Because as I've said in the second point, compensation for loss of earnings, depending upon what earnings were lost, it could be significant, and in certain cases possibly even rival the quantum, rival the sums awarded in unlawful detention claims. There are two, going down to the last point there are two areas which I think are potentially ripe for Article 8 claims. And that's the ETS litigation and the 3225 tax discrepancy cases, because it's the nature of those cases that when somebody has been found to be dishonest and or fraudulent, of course, their right to work or their ability to work is completely curtailed, and that's made good, as Lady Justice Timler said, by the policy of the Home Office and by law. So if it's subsequently found that even on the ETS authorities as they currently stand,
you might want to just expand on what ETS is.
Yes, I do apologise. So ETS is effectively, for those who are not familiar with the immigration practice, a few years ago now, Panorama did an investigative programme whereby it found that there were numerous colleges, in inverted commas, who were conducting English language tests fraudulently. those English language tests are required in order to comply with certain requirements of the immigration rules. And so what that led to was a response where literally, I think, tens of thousands of individuals had their leave cancelled as a result of allegations of fraud. Allegations of fraud, that they fraudulently obtained these. Now, there's been an enormous amount of litigation, and it's quite complex, as to whether or not the allegations of fraud even make or even discharge a primary, what's come to be known as the primary evidential burden. And that is still the subject of litigation at the moment. I myself had an unreported case in the upper tribunal which found, in light of recent evidence given before an informal parliamentary committee, that the evidential burden was not discharged, but that's unreported and the matter is subject to appeal. But what normally happens is that the matter ends up in the first tier tribunal, and a judge determines whether or not, in light of the generic evidence which is supplied by the Secretary of State and the individual evidence as it attaches to the appellant, whether or not the allegation of fraud is made out. Now, if it finds that the allegation is not made out, it seems to me that the basis upon which, the basis upon which their leave and the attached right to work was cancelled is also not made out, and the provision or the authorities are that the Secretary of State will normally undertake to put the individual back into the position they were prior to the cancellation of leave on the basis of the allegation. But it seems to me that it's a classic example where there could be a claim for loss of earnings. And similarly on the what's known as 3225 tax discrepancy cases, they're cases where allegations of dishonesty have been made, where it's been found that, or it's been alleged or concluded by the Secretary of State that an individual has declared a different amount of earnings to the HMRC than those that they've declared to the Home Office, because obviously there's an interest in claiming more earnings to the Home Office because there are certain thresholds which need to be met and less to HMRC. And again, that has been subject to quite extensive litigation, and also a number of individuals it's been found that in fact that's not made out. So again, that seems to me a potential claim for loss of earnings if it's found that the initial decision was unlawful.
I think we might disagree with each other on this, mightn't we? Because I have concerns that were such a case to go before the court, they would look at whether the initial finding of fraud, albeit subsequently it turned out to be wrong, was reasonably made. Yes,
I think it's an interesting point, yeah. And I think
because I struggle with a court finding for a claimant in circumstances where it was reasonable for the Home Office to conclude that there had been fraud,
yes.
And in many cases there won't be the evidence to do that,
yes.
But if it was reasonable, it seems a very harsh decision to then compensate the individual for losses.
Well, I think that is. I think that if one approaches it from a common law point of view, that's inevitably the case.
Yeah.
The complexity with this is that it deals with rights, and these rights are not limited in that sense. Once it's been established, of course, there's proportionality and things in terms, but once there's a breach, the demand is just satisfaction. So the question is, has there been the counter-argument would be, if there's been a breach, there's been a breach. But what I think is particularly interesting in the ETS litigation, especially if it comes to the point where the higher courts find that the initial evidential burden's not made out, then I think it will be very difficult for the Secretary of State to argue, therefore, Well, although even that, because of the information changes, so they could, I think social workers could still go back and say, well, it was reasonable at this time, and it was shown to be reasonable because the court said. But one thing that does, that I wanted to ask you about that is it potentially, arguably, arguable under the Caparo test that this is one of those novel categories? Because the Secretary of State is not just exercising the statutory scheme, arguably. By making an allegation of fraud, it is arguably going beyond that.
Yeah, I think it probably, arguably is, but also...
But this would be one of those cases where you have to apply the Caparo test.
Possibly, or yeah, possibly. I mean, it could be analysed as it's an act case where you accuse someone of fraud. So Home Office does the act of accusing someone of fraud, which has the consequences of removing their ability to work or whatever it is. Although
the interesting case, of course, within those provisions contemplate dishonesty, or at least 3225. Exactly. So it's that part of the statutory scheme. And it is an allegation of fraud going beyond a mere allegation of dishonesty. So it's quite interesting. Especially the 3225 point. I think that will be a more finely balanced one. The ETS litigation, I think would probably be on stronger grounds.
I think the problem with the tax discrepancy cases, though, on that is you get into all sorts of knotty issues about pure economic loss, because the only way that you can recover for pure economic loss is if you fall into that assumption of responsibility category. So if you're just an act case applying Caparo, your question is, does the scope of the duty of care cover pure economic loss? Well, don't know the answer to that.
And ETS, would that not? It wouldn't just be pure economic loss, I suppose.
It depends if there's a psychiatric injury caused as a result of it, but yeah.
So I think the long and the short of it is that there are enough imponderables here for it to be wise for claimants to, at least in these type of cases, still argue both heads.
Oh yeah, absolutely.
And no doubt that's going to be a headache for the Home Office, but
thanks.
And I do apologise in advance.
Okay.
But anyway, thank you very much for attending. Sorry we've rabbited on, but thank you very much, Katie, for your contribution. Any questions? Yes. No questions from anyone. If you do have any questions, then I think the last slide has our emails, so we can.
You're very welcome.
Thank you very much. Thanks.
No email addresses, but you.
Oh, I do apologise. I thought there was. Okay.
No, don't worry. But thank you very much for listening, everyone. And no doubt we'll be back with another one about level of damages.
Yes, and ask a late as well. Yes.
Oh, here we go.
What's the result of the question of the tribunal jurisdiction? Well, it was found very clearly that the tribunal did have jurisdiction, and I think that was relatively uncontroversial, because the upper tribunal has the same jurisdictional scope in that regard as the High Court, and of course provision is that you can attach a claim for a declaration and a damages claim to a judicial review claim, if, in relation to the damages claim, you would have had a freestanding damages claim. That does raise questions as to where the appropriate forum is, and there's been a shift in this, because initially Lord Wolfe said in Anu Frageva that basically he said that if you're going to make a claim for damages under the Human Rights Act, you should proceed by way of judicial review. But most things have moved on very substantially since then, and I think, or to quote, for example, McGregor on damages, that is probably no longer good law. In fact, where there's a substantial dispute of fact, it will probably be much wiser to bring it in the Queen's Bench Division under Part 7. There's also a question from Mr. Mohammed Robiullah. How can you calculate damages? Well, that is the question that both Katie and I are still working on. Hope to have some information in due course. The question is, it's quite difficult because the reference in the Human Rights Act is that you follow the jurisprudence or take into account the jurisprudence, including, it's been held, calculation of damages of the way in which damages are calculated by the European Court of Human Rights. The European Court of Human Rights, importantly, does not make determinations of fact. It's effectively a grand appellate jurisdiction. And so it would not have the ability to calculate damages in the fine-grained manner that would be normal in first instance, in courts hearing first instance tort cases. There has been some jurisprudence recently which suggests that taking account of this difference means that it is likely that, and this goes to the standard of proof question, that the standard of proof would be taken to be the normal civil standard that would apply in tort cases. But there is a real question as to, I mean, the authority such as it is that, and this goes back to Lord Bingham, is that it is a very different jurisdiction. Does that mean that you can't take account of the way in which damages, particularly pecuniary damages, are calculated in tortious cases? Well, I've noticed, and it's very difficult to specifically refer to it, but I get a feeling that the courts are becoming more and more sympathetic to using those tools in order to calculate damages.
The case that I would have a look at that's really useful, again, it's an absolutely mammoth judgment, is the case of Al-Saran. Al-Saran and the MOD. It's a 2017 case. And I think if you read Al-Saran, what you come out with is you calculate the damages as if, essentially, it were a common law claim, but then you apply a reduction to that figure to take account of, for example, the claimants in Al-Saran were Iraqi. You take account of sort of the value of money in the claim that the claimants are coming from, if it's an international
Which
claim.
is a distinctly ECHR approach.
Exactly, yeah. So Al-Saran sets out various considerations that you take into account. Have a read of that, and I think what you end up with is, I think it's a really overlooked judgment, but what you end up with is a feeling that actually damages might be very comparable across the common law and the ECHR.
What is and what has always been a bit of a punt is how the European Court of Human Rights calculates non-pecuniary loss, and that's in the case of Faulkner that was recognised. I won't say who it is, but I have a friend who's a retired judge of the European Court of Human Rights, and I happen to, there's been a rumour for a long time, but there is in fact a schedule which the judges of the European Court of Human Rights have, but is not disclosed, which is astonishing. And they use that schedule to determine what is likely to be an appropriate amount for the awarding of non-pecuniary loss. They don't want to disclose it because they want to retain their discretion. Now, there's one other question here. If someone's wrongly curtailed leave to remain on the basis of TOEIC after 6 years, this has been rectified and accepted the decision was wrong. What is your take on its merits? Well, it would depend on the facts. What should be mentioned, or what that does raise, is the fact that there is a 1 year time limit or limitation period for damages for claims under the Human Rights Act. However, jurisprudence, or there has been jurisprudence to suggest that where it's a damages claim, the courts will be much more willing to extend, and that I'm aware of at least one case where they've extended it to over 6 years. They'll be much more willing to extend the 1 year time limit so that it's comparable to a claim.
Although also on that case, you would bear in mind that it's probably continuing. Anyway.
Yes, yeah.
So the time that it would start running would be when the loss stopped occurring.
Yes, absolutely.
So you might still be okay.
Yes. Can a victim get damaged from out of the country?
Damages.
I don't quite understand that, but maybe.
But if there are further questions.
Yes, please. Our emails are. My email is rwilcox@onechancerylane.com, and Katie's is kayres@onechancerylane.com. And if not, you can send the questions through to, I believe, the host. But thank you very much. Thank you very much for attending.
Thank you, everyone.
Bye-bye.
Bye.